Okay, thank you. Is everybody able to hear me okay? I'll take that as a yes. I'm Jane Allen, and I'm a staff attorney for North Penn Legal Services, and it's a pleasure to be with you today to be able to do Step 5. Step 5 is part of the Social Security disability programs. I'm just going to give a broad overview of the disability programs and the sequential process. I know Kristen did an awesome job 2 weeks ago on the adult sequential process, so I'm not going to go into a lot of detail, but for people who weren't able to make it to that, just so you have some idea of, where Step 5 fits in the process. Basically, there are two disability programs. There's the Social Security Disability Income Program, better known as SSDI, and it's a program that's designed for people who've worked and paid taxes into the Social Security system prior to becoming disabled. If an individual is judged disabled, the individual will receive SSDI benefits regardless of the individual's assets or family income. So SSI is just a program for people who have worked, paid into the Social Security Disability Program. And I like to think of it as an early retirement fund. If you make it to full retirement age, the wages that you've paid in and the taxes that you paid in become your retirement fund. If you don't make it to retirement age because of disability, then you get money from that same fund. And I'd like to, like I said, to look at it as a sort of an early retirement fund. The other one is supplemental security income, and SSI is a needs-based program. It's designed to pay benefits to disabled people who need help with basic living costs, housing, food. And if you haven't worked or paid taxes into the Social Security system, to qualify, you cannot have family assets or income over a certain limit. And right now that asset limit is $2,000 for an individual and $3,000 for a couple. So these are the two programs, disability programs. You hear clients get confused a lot, and they'll say, I'm on disability. And to be honest with you, they're not really sure what program they qualify for. So when you have clients, you need to know which program they qualify for so that you can better serve them. And just a broad definition of disability, the Social Security Administration defines disability as the inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairments which are expected to result in death or which have lasted or can be expected to last for a continuous period of not less than 12 months. And that's pretty much the general definition for both programs. Once you've determined which program a person is eligible for, the definition of disability is the same for both programs. And the sequential process used by the Social Security Administration to determine whether you are disabled is the same. There's not a separate determination factors for one program versus the other. Once you've qualified for one of the two programs, the sequential process is the same for both. So I'm just going to briefly go over this. Kristen did an awesome job of doing it a couple of weeks ago, but I just want to make sure that you know where Step 5 fits into the overall process. The first step is substantial gainful activity. Substantial gainful activity, is the Social Security will examine your work activity for a period you are claiming disability, okay? And this can include the value of any volunteer work you have, any hobbies like you go to craft shows and sell. The SGA for this year is, for last year is $12,060 per month. If you're a blind applicant, then that amount goes up to $2,110 per month. If you go over SGA, if you make too much money in a month, you don't qualify for disability benefits regardless of the severity of your impairments. So if you are in a wheelchair and you are still managing to do an office job and make over substantial gainful activity, despite the fact that your impairments would probably qualify you for disability, you are not going to be found disabled if you're over that amount. The second is a severe impairment. And a severe impairment is generally defined as an impairment that significantly interferes with the performance, your ability to perform a work-related activity. That's kind of nebulous, but it is not a high threshold to get over. Severe does not mean disabled. You can have a number of severe impairments and still not considered to be disabled. For example, I wear hearing aids for a hearing disability, but that doesn't, it would be severe, but it doesn't make me disabled. And you must have medical evidence to support the severe impairment. And it must last or be expected to last for 1 year or result in death. Step 3 is the listing of impairments. And step 3 and step 5 are the most important steps as far as determination of disability. This listing is a book that the Social Security publishes that has, for each body system, there's a list of medical conditions that are so severe that you automatically qualify for disability. If the condition is not on the list, then Social Security can decide if you have a condition that equals a medical condition. Some of those type things are, you may have rheumatoid arthritis or fibromyalgia or something like that that doesn't necessarily meet one of the listings, but the severity of your symptoms are so bad that it equals the severity of that listing. And generally, listings require very specific medical evidence, lab tests, pulmonary tests, MRIs, x-rays. It's a very high standard. And if you meet A, B, and C of a listing, but you don't meet D, then you don't qualify for the listing. So most cases go on to the next 2 steps. Next step is past relevant work. Social Security will examine your work history for the past 15 years. The work that you've done, in order to qualify as past relevant work, it has to have been done at SGA. And it must have lasted long enough for you to gain the skills needed to perform the job. Now, we're going to talk a lot about skills and skill levels and that later on, but generally, even an unskilled job, you have to have at least 30 days of training for it to be considered long enough for you to have acquired the skills to do that job. And step 4 is also important because you need to compare the claimant's current RFC, residual function capacity, to the physical and mental demands of the past relevant work. Now, I put in there criminal activity is excluded from past relevant work because even if you were very good at stealing cars, it doesn't count as income. And I'm not sure why SSA needed to put that in there, but it is one of the exclusions. The last step is step 5, and it's all other work in the national economy. If you can't do past relevant work, is there any other job in the national economy you can do? And step 5 has a lot of moving parts. It's the most complicated and also the most important because 90% of your cases, or even more than that, are going to go to step 5. I find in my own practice, as I've worked with Social Security over the years, that if somebody is going to be found disabled by the listing, it's generally at an earlier step in the process than someone who reaches the administrative law judge or a hearing stage. If it's severe enough to meet a listing, generally it will be found at one of the earlier levels of the adjudication process. And so I'm going to focus primarily on administrative law judge hearings as we go through step 5. At step 5, which is the last step, an individual's RFC, or residual function capacity, and age, education, and work experience are considered to see if they can make adjustments to other work in the national economy. If an individual cannot make an adjustment to other work, he or she will be found to be not disabled if they can make adjustments. But if they can't make adjustments to other work, then they'll be found to be disabled. So this sort of presumes that you've worked before, you have a past relevant work history. There are people who have not worked at all, and step 5 also will cover them, having no past relevant work history. The definition of disabled for step 5 is slightly different. An individual shall be determined to be disabled only if the physical or mental impairments are of such severity that he not only is unable to do his previous work, but considering his age, education, and work experience, engage in any kind of substantial gainful work which exists in the national economy. And that's regardless of whether such work exists in the immediate area where the person lives, or whether a job vacancy exists for that person, or whether he would be hired if he applied for that work. For purposes of the preceding sentence, which with respect to any individual, work which exists in the national economy means work which exists in significant numbers, either in the region where this individual lives or in several regions in the country. So, the upshot of that is that if you are living in Northeast Pennsylvania and a job does not exist in the town which you live in, the Social Security presumes that you will in fact move to go and find that job, regardless of whether it's minimum wage or not. So it's not a realistic standard for much of the country. Once you get to step 5 and you've proven you can't do your past relevant work, then the burden of proof shifts to the commissioner to provide evidence that demonstrates jobs exist in significant numbers in the national economy that the claimant can do, given the claimant's RFC, age, education, and work experience. Okay, and once you make it to the final step, you do not have the duty to show that you cannot do any jobs in the national economy. The Social Security has the duty to show there are jobs that you can do in the national economy, and they do that through the use of a vocational expert. The burden of proving your RFC does not shift. In other words, although your residual function capacity is an integral part of what they're going to use to find whether you are disabled or not, that RFC is still your responsibility to prove through the use of your doctors and other medical testing, and that that RFC is used not only for step 5, but often for step 4. So step 4 and step 5, your residual function capacity becomes very important. And I'll go into what exactly that is and how it's used in a minute. The burden of meeting the commissioner's burden of proof can be done by vocational expert testimony, or it can be done by using the medical vocational rules. And I'll talk about both of those in a minute, but those are really the only 2 ways that the commissioner can meet the burden of showing that you are able to do work in the national economy. And when I say the commissioner, I mean the administrative law judge acting on behalf of the agency. Okay, the medical vocational rules are also called the grids, and they can be found at 20 CFR Part 404, Subpart B, Appendix 2. Generally, we just refer to them as Appendix 2. And they're based on exertional limitations only. They don't cover non-exertional limitations, and I'll talk a little bit more about non-exertional limitations, but that's things such as fatigue or pain or low tolerance to stress. The medical vocational rules came into being because decisions were being made all over the board by all different administrative law judges all over the country. The grids were designed to give more consistent decisions. If you fit the criteria of the grid, you were disabled or you were not disabled. The grids contain 3 charts, and it's like a big spreadsheet. And the spreadsheets are made up of sedentary, light, and medium work. Those are the 3 charts, and then within them there are specific categories, and it determines whether a person is disabled based upon their RFC, whether that be sedentary, light, or medium, and their age, education, and work history. If a claimant's profile matches one of the rules in the medical vocational rules, then the administrative law judge is bound by that rule. They do not have to specify specific jobs. It is an underlying assumption that there are sufficient jobs in the national economy if a person meets the criteria of one of the medical vocational rules. Cases that do not have cases that have non-exertional limitations do not fit in the grid. You cannot use the grid for examining things like pain and fatigue. So in that case, you would then have to go to the vocational expert. The grids are also used as a framework for the vocational expert's testimony, and I'll also get into that a little bit, but most of the hypotheticals that the judge uses to question the vocational expert are premised around the framework of the medical vocational rules. Okay, the medical vocational rule categories are age, education, work experience, your RFC, and your transferable skills. Those are the things that the medical vocational rules will look at. I know I keep saying, age, education, work experience, RFC over and over again, but those are the, those are the points that you need to take away from this, is that those 4 things are critical to any analysis in step 5. Okay, age. Age is defined in the Social Security regulations as 19 to 49, you're considered to be a younger individual. When you reach 50 to 54, you're closely approaching advanced age. When you reach 55 or above, you are considered to be of advanced age. Now, those of us that have passed 55, that is disheartening, to say the least, that Social Security considers me to be of advanced age. Next. There are some special age rules that you should be aware are out there. 2 in particular are outside the medical vocational rules. The first is what's called the worn out worker rule. And it's a worn out worker is somebody who has done arduous, unskilled physical labor for 35 years with a limited education. Doesn't specify an age, but generally, if you've been at work for 35 years, even if you started when you were 15, 16 years old, you're more than likely in your 50s now. But if you meet that criteria, you've done arduous work for 35 years, you have a limited education, and we'll talk about what that is, then you are automatically under the regulations disabled. The second thing is no work experience at all. If you're of advanced age, 55 or older, and you have a limited education and absolutely no work history, then the regulations also presume you to be disabled without going to the medical vocational rules. There are other milestones with age, and I'll get into some of these in a minute, but once you reach 50, it's kind of a magic threshold. If you are 50 years old and you have done primarily physical labor, either medium or heavy labor, and you are found that you can only do sedentary work, and there are education limits on this as well, and you don't have skills that are transferable to more skilled work, then they're going to find that you're automatically disabled under medical vocational rules. And the reason for that is once you reach 50 to 54, and you're only able to do sedentary work, it's difficult to train you to do office jobs because often these types of individuals don't have a lot of computer skills. They're not familiar with, the more technical architecture, medicine, legal, secretarial, jobs that are generally found in sedentary work. Once you reach 55, it gets even easier. All you need to show at that point is that you are only capable of doing light work. And once again, you have to keep in mind that these are people who have done, more difficult work, who have more limited educations, and their skills are not transferable to skilled work. For a younger individual, the standard is exceedingly high. You have to show that you can do less than sedentary work. And your education and work history are generally not going to be looked at. Even if you have a very limited education and a limited work history, if you can still do sedentary work when you're a younger individual, you're not going to be found to be disabled under the medical vocational rules. So those are things to keep in mind. If you have clients who come in the door over 50 years old, that should spark, the antenna should rise. The same with 55. And I also, caution you to keep in mind that I get a lot of clients who come in at 58, 59 years old, and they're waiting for their hearing and they cross one of those thresholds. So that's something to keep in mind for the hearings. Oftentimes they don't necessarily come in over that age. They may come in at 52, 53, but because the process is so long, they may actually cross one of those thresholds during the time that you're representing them. So you need to keep that in mind as well. Borderline age, and this is important too for what I was just talking about. Sometimes you get a client that comes in at 47, 48 years old, and they really are worn out. They've been a stone quarry worker, or they've done personal care home, lifting heavy patients, and they've gotten to the point where their body has worn out, but they haven't reached that threshold yet. And according to the regulations, the age categories are not to be applied mechanically in borderline situations. A borderline situation may exist where a claimant was within a few days or a few months of attaining the next higher category. For example, a claimant may be deemed an individual of advanced age at 54 and 11 months. And in some circumstances, even though that individual has not quite attained 55 years in chronological age. I have had judges go back as far as 6 months. More likely, and I found that I've had people that about the 4-month range seems to trigger it. But it is somewhat in the discretion of the judge, but it's something you certainly could bring up to the appeals council if you're denied that your client was of borderline age and was not found to be disabled. Next is education. And education in general, they use the highest grade you completed in high school. So when I ask a client, how far did you go in school? They'll say 8th grade. And I'll say, did you finish 8th grade, or did you start 8th grade and not complete it? And oftentimes it'll be the case where they've started 8th grade. I had a client recently who started 9th grade, but they wanted him to then go back and repeat 8th grade, so he dropped out. So technically the highest level in school that he completed was the 8th grade. There is a presumption, though, that if there's strong evidence that the academic achievement is lower than the last grade completed, it will be considered. For example, a student that graduated from high school but was in all special education classes where they received like one-on-one help with assignments, the tests were read to them, other accommodations were given, you may be able to show the client, although they technically have a high school diploma, it doesn't necessarily have a high school education. Education means formal schooling, okay? It can be homeschooled, but it has to be in a formal schooling situation, or other training that contributes to the claimant's ability to meet vocational requirements of work. And that could include like a VOTEC program where you learn to be a mechanic or something like that. The schooling has to be gauged toward such basics as reasoning, arithmetic ability, and communicating. So in other words, like for arithmetic, for an unskilled job, you still have to be able to do simple math. And when they say simple math, they mean adding, subtracting. I don't even think you have to multiply or divide. You need to be able to make change, that kind of thing. And when we're talking about math, we're talking about very simple math. Communication, we're talking about being able to communicate at a level where you're able to understand simple instructions that are given to you. Education categories, how they determine an individual's education category. Illiteracy in English is generally below fourth grade education. They presume if you've made it to fourth grade, you've been taught somewhere along the line how to read. So illiteracy will generally only be found under fourth grade. A marginal education is sixth grade or less. A limited education is 7th to 11th grade. And high school education and above. They generally don't distinguish between a GED and a high school education. And also they generally don't distinguish between high school and college. There's not another college category for people who are college educated. So, but they will take that into account when they look at skills and transferability of skills. They will look at whether you have had college education and what those courses were in. The inability to communicate in English used to be part of the first category. It was illiteracy in English and an inability to communicate in English. That has been removed as an educational category this past year. Prior to that, you were considered to be illiterate or unable to communicate in English. That was generally considered to be the lowest level of education. But as we know, there are people who don't speak English, who have been, through college and have, high levels of education. They just don't speak the language. Work experience is broken down into your different skill levels. Past relevant work experience in the grids is expressed in terms of exertional and skill level. Social Security determines skill level from specific vocational preparation. And I'll go into that a little bit more when I talk about the Dictionary of Occupational Titles. But suffice it to know that the SVPs are based on the amount of time that it takes you to learn a task. So an unskilled job would be an SVP of 1 or 2. Semi-skilled would be an SVP of 3 or 4. And a skilled position is 5 through 9. And as I said, the classifications are based upon how long it takes to learn the work and the qualities and characteristics of that particular job. So any unskilled work would be generally under 30 days to learn, between 0 to 30 days to learn how to do the job effectively. And it goes up from there. And those 3 skill categories are found in the Code of Regulations at that site. And they are also discussed in Social Security Disability Ruling 83-10. Almost everything I cover today is covered by one of these Social Security rules. It has been pointed out in other presentations that Social Security uses a number of different sources for their information. They use the HALEX, they use the POMS, they use the regulations and the Social Security rulings. So you should have some familiarity with the rules and regulations that Social Security is using, and then that's really a whole nother day's presentation. But just be aware that they're out there, and I know they've been touched upon on some of the other sessions that I've listened to. What is the definition of a skill? Because if we're going to talk about transferability of skills, we want to know what we're talking about when we're talking about a skill. A skill is knowledge of a work activity which requires the exercise of significant judgment that goes beyond the carrying out of a simple job duty and is acquired through performance of an occupation which is above the unskilled level. So the significance of that statement is that in order to gain a skill, it must be done at an SVP of at least 3. If it's an SVP of 1 or 2, then you're not generally found to have acquired a skill. Unskilled labor is just that. It's work that, it takes you 30 days to learn, but it must be a skill that takes you longer than 30 days to acquire. The POMS, which are the program manual that is used by the Social Security disability workers. Social Security workers use the POMS as sort of a guideline on how to find in particular cases. They're kind of the rules of the road for Social Security workers. For the disability program purposes, claimants can gain skills from experience and demonstrated proficiency with work activities and past relevant skilled or semi-skilled work. Claimants cannot gain skill from unskilled work, which I talked about earlier, work that was not relevant, volunteer work or hobbies, or purely education. You actually have to have gone to work to do and acquire the skills. It can't be something that you just learned in school, even if that school was college. Next thing is work experience, the skills levels. I'm sorry, I think I went backwards. Okay, unskilled work. I've touched upon it a little bit. It's SVP of 1 or 2. But unskilled work needs little or no judgment to do simple duties that can be learned on the job in a short period of time. They may or not require considerable strength. Oftentimes unskilled jobs will be heavy labor intense, but not decision making. But that's not always the case. A person can usually learn to do the job within 30 days, and there's little specific vocational preparation or judgment needed. No work skills are gained from unskilled work. That's important because of the fact of transferability of skills when we get to that later on. If your person, your client has only done unskilled work and they are over a certain age and we're looking to see whether their skills are transferable in the medical vocational rules, the answer is no if they've only done unskilled work, and they will automatically be found to be disabled. So that's an important point. Semi-skilled work. Now, this is sort of a nebulous, it's not quite skilled work, but not quite unskilled work. Work which needs some skills, but does not require doing more complex work duties. And, that means almost nothing. Work activities are less complex than skilled work, but more complex than unskilled work. It's one of those, I know it when I see it, levels of skill. Coordination and dexterity may be necessary, such as when hands or feet must be used quickly to do repetitive tasks. In other words, if there's pedals that are involved or something of that nature. These jobs may require alertness and close attention to watching machine processes, inspecting, testing, or otherwise looking for irregularities. These semi-skilled jobs are oftentimes inspector positions. And they are tending or guarding equipment, property, materials, or persons against loss, damage, or injury. So security type positions where you need to pay close attention to what's going on around you. Skilled positions require qualifications in which a person uses judgment to determine the operations to perform in order to obtain the proper form, quality, or quantity of a material to be produced. In other words, tends to be management type jobs. May require layout of work, estimating quality, determining the suitability of needed quantities of materials, making precise measurements, reading blueprints or other specifications, or making necessary computations or mechanical adjustments to controls or regulate the work. May require dealing with people, facts or figures, or abstract ideas or high levels of complexity. These are jobs that take generally, years to learn, years of education and years of learning. It can be on the job experience. I go from being a machinist to being the machinist supervisor, where I'm making the schedule, I'm doing the budgeting, I'm doing the multifaceted type of jobs. It's sometimes difficult to tell the difference between a skilled and a semi-skilled job, but the skilled job is just, it generally is in the amount of time it takes me to learn to do the work and the complexity of that work. Residual function capacity. This is the cornerstone of the medical vocational rules. It's the cornerstone of step 4, past relevant work, and it's the cornerstone of the vocational expert testimony. So there are more specifics that go into each of these categories, but for general purposes, sedentary work is considered to be lifting and carrying less than 10 pounds occasionally, 5 pounds frequently, standing and walking for at least 2 hours, and it generally requires good use of the hands and fingers. Light work is lifting and carrying up to 20 pounds occasionally, 10 pounds frequently, and standing or walking for at least 6 hours. Now, the biggest difference between light and sedentary, besides the lifting, is the amount of time you have to be able to stand versus the amount of time you have to be able to sit. In a sedentary job, you need to be able to sit for 4 to 6 hours out of an 8-hour day. For light, you have to be able to stand for 4 to 6 hours out of a day. And so that is, besides the weight limits, that is generally the biggest difference. From then on, it's just amount of weight. Medium work is lifting and carrying up to 50 pounds occasionally, 25 pounds frequently. Heavy is carrying up to 100 pounds occasionally, 50 pounds frequently, and standing or walking for 6 hours. Very heavy lifting over 100 pounds frequently, standing or walking up to 6 hours in an 8-hour day. The next thing is a sample of the grid. This, for whatever reason, is not in high focus. It's sort of blurry, but this is an example of a medical vocational guideline right from the appendix. On the first column, we have what rule it is. The next column is your age. And for this one, it's all over 55. It's advanced age. The education level is less, limited or less. Position is unskilled or no skills. And then you're automatically disabled. So when you get a client, you find their age, what their education is, and their previous work experience, and you plug it right into this chart, okay? If they're over 55 and they have limited or less experience, and they've done skilled or semi-skilled work, but those skills do not transfer to other skilled work, then they are also disabled. However, even if you're advanced age and you have a limited education, if you've done skilled or semi-skilled work and those skills transfer to another occupation, then you are automatically not disabled under the medical vocational rules. So you can see why these rules were created. There are 3 charts: sedentary, light, and medium. and they were designed to give a structure to the process so that judges weren't saying, you know, I've got somebody who's 60 years old, doesn't have a high school education, hasn't really done any work, but I find that they are able to do XYZ job. And this automatically sets a framework for the justices to make more consistent decisions. Transferability of skills. Skills are transferable only when they're derived from past relevant work, and that seems sort of obvious. Past relevant work must be semi-skilled or skilled of an SVP of 3 and above, and I talked about that before. Skills are never transferable from unskilled work, an SVP 1 or 2. And transferability of skills is only done when it makes a difference in the determination or a decision. When I go back to the grids, the difference between Rule 201.02 and 201.03 is that the skills for this person are do not transfer to skilled work. These skills do transfer to skilled work. So that person, the transferability of skills becomes important regardless of the person's age or work experience. Now, when there is a question as to whether the job has transferable skills, that decision can only be made by specific jobs from a vocational expert. Okay, the judge cannot say, I believe that these are transferable. You've been a desk clerk, and now you could become a cashier. I think that those skills are transferable. It has to be through the testimony of a vocational expert. Determining transferability. Under the regulations, transferability is most probable and meaningful amongst jobs in which there is the same or lesser degree of skill required. They use the same tools or materials, or they use the same or similar raw materials, products, processes, or services that were involved. Now, this is defined very broadly when you're young, okay? As you reach closer to retirement age or closer to advanced age, the skills must be much closer to the skills that you've previously used. Claimant's age, closer to the transferable skills must be to the past relevant work. There must be little, if any, vocational adjustment in terms of tools, the work process, the work setting, or the industry in which those skills were used. So the older you get, the more strict they are about what is a transferable skill. And that makes sense because it's more difficult to learn a skill or perfect a skill once you've gotten to a certain age where you may not be at the job long enough to reach the sufficient level of training to reach that skill level.
Jane, if I could just interrupt quickly. This is Kelly for the attorneys in the audience. I've just launched the question poll box, a simple pop-up box. If you just respond yes or no, it will take it off your screen. I will leave it up about 2 minutes. Please respond if you're requesting CLE credits for your participation today. Thanks.
Okay. Kelly, the box is still staying on the middle of my screen. Can I reduce that or minimize it?
Yeah, go ahead. Or you should be able just to click off of it.
Okay. Non-exertional limitations. The grids, we talked about using the grids for determining disability based on a number of factors. However, If you have non-exertional limitations, you do not fit into the grids, okay? When the limitations and restrictions imposed by your impairments or related symptoms, such as pain, affect only your ability to meet the demands of other than strength demands, the Social Security considers that you have only non-exertional limitations or restrictions. Some examples of non-exertional limitations or restrictions are as follows. You have difficulty functioning because you're nervous, you're anxious, you're depressed. I get a number of clients who have things like agoraphobia, where they're not able to leave their house. You have difficulty maintaining concentration or attention. Clients who suffer from ADHD or obsessive compulsive disorders often have difficulties paying attention or concentrating. Oftentimes that can also be caused by pain or fatigue as a side effect of medications. You have difficulty understanding or remembering detailed instructions. I have seen that in a number of cases. One very recently where a client had chemotherapy, and the chemotherapy had affected her ability to remember and specifically detailed or instructions or directions or anything like that. You have difficulties in seeing or hearing. And lastly, you have difficulty tolerating physical features of certain work environments. You can't tolerate dust or fumes, heat, cold, that sort of thing. You have allergies. You have difficulties performing the manipulative or postural features of some work, such as you are unable to reach or handle, you can't stoop, you have difficulty climbing, crawling, or crouching. That would lead to restrictions on being able to operate certain types of machinery, be able to perform jobs that required you to be on ladders or scaffolding or something of that nature. Okay. If you don't qualify for the medical vocational rules, either, and there are a number of reasons that I'll go into, then the administrative law judge has the responsibility of calling in a vocational expert. And the vocational expert is supposed to provide impartial expert opinions about jobs that you've held during the past 15 years before you filed for disability. So that's step 4. And your current vocational abilities. An administrative law judge may obtain vocational expert testimony if the administrative law judge needs to demonstrate if your medical impairments keep you from performing past relevant work. So that would be step 4. The judge is going to use the vocational expert to eliminate jobs from step 4 before they're going to move on to step 5. The ALJ needs to know if you acquired any transferable skills in your previous employment. And we talked about that, just a minute ago. The vocational expert is the one that's going to make the determination as to whether those skills are transferable to other work. The ALJ needs to know if there are the ALJ needs to know if your medical impairments keep you from performing any other work that may exist in significant numbers in the national economy, and the medical vocational rules do not apply because your residual function capacity falls between 2 exertional levels, you have non-exertional limitations, or you have a combination of both exertional and non-exertional limitations. So you may fall outside the medical vocational rules for the first reason, if your residual function capacity falls between 2 exertional categories. And that is usually where you, most importantly, we used the example before of being 50 to 54 years old. If your medical vocational, your RFC for being 50 is that you can only do sedentary work, then you would automatically be found to be disabled. However, sometimes a doctor or a medical examiner for Social Security will find that you can lift 20 pounds occasionally but you can't do the standing for 6 hours a day. So you don't meet the exact requirements for light work, but you also don't meet the exact requirements for sedentary work. So the judge will have to put together a hypothetical that gives examples of both of those levels and take into account specific limitations. If you only have non-exertional limitations, you can't use the grids, and you have to use the vocational expert, and obviously if you have a combination of both. The VE questioning. The administrative law judge will ask the vocational expert to respond to a series of hypothetical questions. The hypothetical questions begin, as we talked about before, with the claimant's age, claimant's education, and past work experience. Then they add specific functional limitations, both exertional and non-exertional. After stating the hypothetical, the ALJ will ask the VE the following. Is the claimant capable of returning to any past relevant work, either as actually performed or as generally performed? That is obviously step 4. We have to, with the vocational expert, before we move on to step 5, rule out that the person cannot do past relevant work under step 4. I know this is not a step 4 exercise, but oftentimes a job is performed at a higher level than the actual work level that is listed in the dictionary occupational. I find that a lot with cashiers. Cashiers are light work, but as they were actually performed, they were done as medium work because they had to do stocking of shelves, they had to do inventory, carrying boxes, that sort of thing, so that the work was actually done at a higher level than the level that they performed it at. The vocational expert can look at that job and say, yes, it was performed at a medium level, but the work as generally performed is only light, and therefore they may be able to go back to past relevant work. Next, are there any jobs in the national economy that the claimant can perform given the limitations stated in the hypothetical? If so, the ALJ will ask the VE to list at least 3 jobs by DOT number and occupational title. The ALJ will also ask the VE to provide the number of each jobs that exist in the national economy or local region. Usually the ALJ will build on that first hypothetical by adding additional limitations. So for example, if the ALJ says, suppose I have an individual of 50 years of age with a high school education and a past work history of light work, and retains the residual capacity to do a limited amount of light work, but not the entire duties of light work. And they additionally cannot use ladders or scaffoldings. They have limitations in using foot, pedaling, et cetera, are there jobs in the national economy that this person could do? And then the vocational expert will then name 3 jobs and what the occupational title is. And those jobs can be anything. I've recently been laughing because we've been getting nut sorter as a job recently, surveillance monitor, and job, just about anything you can think of. I had one where it was a shoe packer, where they put the tissue paper into the shoe box and put it over top of the shoes and put it in a box. And that was the job that they described. So these jobs can be pretty much anything. The as I said, the AOJ will generally build on that hypothetical. On average, an administrative law judge will ask anywhere between 3 to 6 hypotheticals, usually some that find work and others that don't, so that the ALJ has evidence to either award or deny your claim. The administrative law judges that I work with in Wilkes-Barre are pretty good about, they will do a hypothetical where there are jobs that exist given the limitations that they specify in the hypothetical. And then they'll add limitations to that hypothetical until there are no jobs that exist. The easiest way and the most common way that they do that is that they'll find the person to be off task for 30% of the time, or they'll find that the person is going to be absent from work 3 to 4 days a year. And then the vocational expert will then say, no, there are no jobs in the national economy that the person with that limitation could do. After asking hypothetical questions, the administrative law judge must ask whether there are conflicts between the VE's testimony and the information found in the Dictionary of Occupational Titles. The most common example of that I see is when the judge asked the vocational expert about a sit-stand option. There are no sit-stand options found in the Dictionary of Occupational Therapy titles. I'm going to need therapy after this. Like I said, the example of that is usually a sit-stand example. There is no sit-stand limitation in the Dictionary of Occupational Titles. So the VE will generally say, based upon my experience in the profession and my observations of work spaces and various businesses, I have noted that there is a accommodation given in X number of jobs. Now, generally, the vocational expert will diminish the number of jobs. Let's say it's a cashier. They'll have to erode the number of jobs that a cashier can, positions that are available based upon that sit-stand option. But the judge needs to ask, since it's not in the Dictionary of Occupational Titles, where did you come up with the information for your assessment? And to be honest with you, most cases are decided by the RFC and not by the vocational expert's testimony. If you're a younger individual and you have an RFC of light, the vocational expert is going to be able to come up with jobs in the national economy that you can do with an RFC of light. Your job then becomes eroding that RFC base through your questions to the vocational expert to get it down to less than sedentary. And then the vocational expert will be able to say there are no jobs available. When you're questioning a VE, the administrative law judge, when they're doing the questioning, the vocational expert is not supposed to provide his or her own evaluation of the medical evidence. The judge will give the RFC. The vocational expert is not the one that goes over the medical records. They generally don't see the medical records. The only thing that they get is the Social Security's past relevant work history, and they're expected to make their evaluation specifically on the occupational, not the medical evidence. The VA is not supposed to state whether you're a proper candidate for vocational rehabilitation. Sometimes it's very obvious in the hearing that especially a young person would be a good candidate for vocational rehabilitation as opposed to trying to get a job right out, out in the workforce unassisted. State whether you could compete with unimpaired individuals for available employment. I get a lot of clients that will say to me, I go to the job interview, but as soon as I say I have a bad back, they're not going to hire me. The vocational expert cannot take that into account. State whether job vacancies exist or whether you would be hired for the existing jobs. They just state jobs that are in the Dictionary of Occupational Titles. They do not state jobs that are available. They haven't gone to, Craigslist or any of these other sites, Indeed.com. They don't have to find out whether those jobs actually are vacancies exist. They just need to determine whether that job fits the hypothetical that the judges ask and exist in the DOT. State whether you can perform in a specific occupation with the same degree of efficiency or productivity as individuals with less than severe or no impairments. That's another one. If I walk in and my impairments are obvious, I may not be on the same footing as someone who walks in who has no visible impairments. And the DOT does not take that into account, nor is the vocational expert allowed to take that into account. Also, the vocational expert cannot say whether you are disabled or not disabled. That is a determination for the judge and not the VE. Although I have had VEs who have been very friendly in that area and have found no jobs based on their belief that their person is disabled. I've had throughout the years some vocational experts that are much friendlier than others, and they hear the person's testimony and will find that there are no jobs, and I know that they've certainly bent over backwards to find that to be the case. Okay, the Dictionary of Occupational Titles. The Dictionary of Occupational Titles contains brief description of 12,741 occupations. Most jobs in the DOT were last updated in 1977, and the latest updates of jobs were done in the 1990s. So this is an out-of-date, antiquated document that really, other than for Social Security, has not been used. The DOT deemed it obsolete and then abandoned by the Employment Service and the Department of Labor. So this is a document that is not widely used as a source document for anything other than Social Security. There are other ONET and some of these other occupational databases are starting to be used, but the official document is the DOT. And that's really a shame because a lot of those jobs don't exist anymore. They certainly don't exist in any of, in this country. They don't exist in regions in sufficient number. It needs desperately to be updated and upgraded because it causes a false dialogue between the attorney and the VE when the VE knows that the jobs that they're suggesting have not been updated since 1977. There's a close link between the DOT and Social Security regulations. The DOT provides the definition of the exertional levels and skill levels in the regulations. So when we're talking about the definition of light, medium, sedentary work, and we're talking about skill levels such as the SVPs I talked about, those were all defined by the Dictionary of Occupational Titles. And the medical vocational guidelines are also based on the number of unskilled DOT occupational titles at each exertional level. So the medical vocational rules are also influenced by this Dictionary of Occupational Titles. And as I said, it's a document that's no longer in wide use, and it's for all intent and purposes obsolete for the Department of Labor and other agencies. The vocational experts are expected to be familiar with the DOT, and you will see that 90% of their testimony comes from their knowledge and use of the Dictionary of Occupational Titles. As a result, you should also be familiar with it and what the various abbreviations mean, what the various categories are. The DOT contains the following: a list of jobs in the national economy as of 1991, a description of the duties and requirements of those jobs, the physical strength requirements of the job, the reasoning, mathematical development, and language development required for the job, the specific vocational preparation, the SVP, or the training period required for the job, and the date that the job was last updated. And as I said, most jobs were updated in 1977. Some were updated in the 90s, but it has been a long time since anybody's taken a look at it. We talked about SVPs before, and here's a little more specific about the SVPs. As I said, SVP of 1 and 2 are short demonstration type rules. Anything beyond a short demonstration up to and including 30 days. These are things that are simple and don't require a lot of education, an ability to read brief directions or to be able to remember brief directions, and that's about it. SVP of 3 and 4 are semi-skilled. And they are skills that take approximately 1 month up to 3 months to learn. And also semi-skilled would include anything that takes over 3 months to 6 months. So, these are fairly basic skills because you can learn them in, as little as 6 months. But they certainly go beyond the level of skill required for an unskilled job. Skilled jobs are generally jobs that require greater knowledge, greater training, and it's usually over 6 months up to and including a year. SVT of 6 would be 1 year up to 2 years. 7 would be 2 years and up to 4 years. 8 would be over 4 years and including up to 10 years. And 9 is over 10 years. And if you've ever been to Corning Glass Company, their top glass blowers have to have over 10 years of experience before they can touch any of the more sophisticated pieces that they do. So we're talking about, jobs that have a very high skill level. Are there any questions, Kelly?
We don't have any questions so far. I think you're explaining things so well, everybody's got it.
Either that or they've gone to sleep.
Hopefully not.
Yes. Okay, we talked about the exertional levels. I'm just going to go over them again real quickly. I'm sorry. Okay. General Educational Development Scale is one of the parts of the DOT that you should also be familiar with. It's composed of 3 divisions: the reasoning, mathematical development, and language development. The scale of GED goes from 1, which is very basic, to 6, which is high level functioning. And an explanation of those can be found in the DOT Appendix C. But the reason that's important is if you have a client who's having trouble or difficulties concentrating or memorizing things, or they have problems with counting money or doing simple mathematics, or they have a a disability in being able to do reading comprehension or retaining information. Sometimes you have an unskilled job, but it will have a GED scale that is above that what your client is able to do. So you may want to take a look at those as well. It's just one component of the criteria of the individual job, but I don't use it a whole lot. But every once in a while, I'll have a client where I'll take a look at the GED scale and say, even though this is semi-skilled work or this is unskilled work, they're not capable of doing one aspect of that because they're not able to read, or they're not able to do simple math, and or they're not able to work under any sort of stress would interfere with their reasoning abilities. Significant number of jobs in the national economy. This is, Social Security hasn't defined the term significant number of jobs. So it can be difficult to challenge the vocational expert on whether the number of jobs in the national, local and national economy constitute a significant number. It's not uncommon for the VE to cite job numbers that have no factual basis or based on outdated reports. Scary as that is, they'll sit there and rattle off local and national numbers that have no basis in fact. Always ask the vocational expert for the source of the data on the significant number of jobs. Where are they getting that number from? Sometimes there are official sources that they will use. Other times it's a little more nebulous to get an answer from them. The DOT does not define jobs and does not report on the availability of jobs. The vocational expert may rely on his or her professional knowledge and experience and various other sources of information, including federal or state government publications. However, if they do that, they have to let you know what publications they're relying on and that they've gone outside of the Dictionary of Occupational Titles. And we talked about that earlier. VE testimony is often inconsistent. It has an unclear factual basis and is not testable or susceptible to rebuttal. Oftentimes, a vocational expert is very unclear about where they're getting their information from. The information from the Dictionary of Occupational Titles is pretty clear, and you can question them on that. But when it gets to some of these other things like numbers of jobs in the national economy or sit-stand alternative, it's difficult to pin them down as to where they got that information from. And that can be fertile ground for you to do some of your cross-examination to make it clear that the vocational expert really hasn't laid a foundation for where they've gotten their numbers. We're doing a whole cross-examining of vocational experts on Thursday, so I have not gone into, I've just put a couple of bullet points together, but I have not really gone into anything to do with the vocational expert testimony itself. I haven't given examples or anything like that because quite frankly, we're going to be spending 2 hours on Thursday, and I would encourage any of you who have any interest in the cross-examining of the vocational expert to sign up for that that seminar. And we'll be doing breakout sessions and doing actual examples of the types of questions you should ask. But suffice it to say, for the purposes of this presentation, that you should always ask for the DOT numbers of the jobs the VE is testifying about that the claimant can do. Never question a VE who has not testified adverse to your client. I call this the quit while you're ahead rule. I've seen more than once where a vocational expert has listened to the hypothetical and said, no, Your Honor, there are no jobs that fit that criteria. That's the end of the day. You fold up your papers and you get ready to go home. I have heard of attorneys who have gone on to question the vocational expert, and that's just a waste of time. You've gotten the answer you want, run with it. Always prepare to present your own hypothetical questions. And that's something we'll be doing on Thursday, is getting some of those hypothetical questions and how you may want to answer them. Always assure that the VE is testified regarding the effects of the claimant's alleged limitations if found credible. In other words, sometimes the administrative law judge will pick and choose limitations that your client has. If through testimony other limitations are creditable, then you should ask about them. My client says that she is unable to pick up buttons because of numbness in her fingers. She's not able to manipulate zippers. Could this person do the type of work you've described in DOT number and whatever? You know, be specific as to what those limitations are. Don't just say, you know, they can deal with low stress. You know, make sure that you explain what level of stress they can deal with and how that may relate to specific jobs that the vocational expert has designated. Where you have several medical opinions which preclude work, ask the VE about each one individually. Sometimes it also will help to ask about them in combination. But if you've got positive medical opinions that say that the person can't do work, and the judge has given a hypothetical that says there are jobs available, then you need to cite those medical opinions and as creditable sources when you ask your questions. Because the judge will certainly use the criteria that they get from their own medical experts. When they have an ME examiner, oftentimes they'll read, I've had judges read right from the medical examining source, not examining source, a non-examining source, a non-treating source, and will read directly from their RFC what things they were able to do and not able to do. And if you have a critical medical opinion that precludes work, you may be able to read that as well and say, if the person has this, this, and this, are they going to be able to work? You do not have to necessarily say the source, but in your closing argument, you can say, you know, clearly the medical vocational expert agrees that given the medical opinion by Dr. So-and-so, there's not going to be any work available. Be familiar with all past relevant work, even if the job doesn't exist anymore. I've been tripped up a couple of times, and I know this is more step 4, but where the VE has started to testify about past relevant work that I was not aware of. And there really isn't a reason for that. Sometimes I'm not sure where the vocational expert has gotten their information from, but your client hasn't fully stated all the jobs they've done. And sometimes it can come out of left field. And you want to make sure that you've ruled out all past relevant work, because if you haven't, you're not even going to get to step 5. Try to keep your cross-examination brief but thorough. Sometimes your real audience is the appeals counsel and not the administrative law judge, and that can be quite difficult. I've had hearings where I've been sitting there and I know that I've lost with the particular ALJ I'm in front of, through all their questioning, through their questioning of the vocational expert. They only asked one hypothetical. They were very brief in their questioning of my client. I know that things have gone south. So sometimes my real audience is the appeals counsel, and that can be very annoying to a judge who's trying to get through a case that they consider to be one without merit. But I have to remember who my audience is, and sometimes I'll have to ask questions that will you know, annoy the judge, keep the judge in a hearing longer than they intended to be, but they're important to my client, and in zealously representing them, I have to make sure that I keep in mind that my audience may not always be in the room. And lastly, ask questions until the VE states that there are no jobs. And what I mean by that is, even if you have to get to the point where you say, okay, due to this or that limitation or impairment, my client is going to be off task 20% of the day, or need to take unscheduled breaks at will, or is going to be absent for 3 to 4 days per month. Are there any of the jobs that you've named that would still be available? And generally at that point, the vocational expert will say no. You always want to end your presentation with a no answer from the vocational expert. And that is it for
Jane?
my presentation. Yes.
We have a question.
Yes.
What is the percentage of cases that win in the appeals council stage?
Oh, I used to have that number. I have that on another presentation, but it's, I don't want to misspeak. I can find that out, but the amount of cases that win at the appeals council is very low. There are some other experts that I see that are on this presentation that might be able to pipe in and give you those numbers. But I think like the reconsideration stage, there's only like 7 of 8 get rejected. The appeals council stage, I think it's maybe 20%. I don't even think it's that high. You have a much better chance at the federal district court level than you do at the appeals council.
Somebody actually commented nationally, usually 10% or less.
Yeah, that's about right. That's about right. I said 20% generously, but I think in all actuality, 10 is probably. Fewer cases go to federal district court than go to the appeals council, but of those cases that do go to the federal district court, more are approved because the judges tend to use a much broader brush when it comes to examining things like pain and other non-exertional issues.
Okay, I'm going to ask that anyone else that has any questions or comments, please type in them in the chat box. I need to launch the second CLE poll box, but I'm not able to get my menu bar to come up. So Jane, if it's okay, I'm going to stop sharing your screen.
Yes.
And see if that might bring back my menu to me. And let's see here. There we go. Okay, now I'm going to launch the second of the attorney CLE poll questions. I will give you a minute and a half, 2 minutes to respond. In the meantime, if you have any questions or comments, please put them in the chat box. And I think we have a few here. Let's see. It says that, oh, here we go. Now that inability to speak English is no longer considered when assessing a person's ability to work, how does the VE determine the person's ability to read, write, and speak on the job? For example, if a client went up to 8th grade, still limited education and not illiterate, but she does not speak, read, or write any English, can we knock out all the jobs that are GED R3?
That's a very good question. My off the cuff answer would be yes, but I'll be honest that I'm not exactly sure how they determine that now. Those regulations went into effect in January of 2020. I have yet to have a case of someone who is not able to speak English. I mean, I know that they have interpreters that they use at the hearings, but I don't know how they make that assessment, to be honest with you. You know, short of asking the questions through an interpreter, as far as, but if they can't speak any English whatsoever, I don't know how you get out of the, you know, the GED. Sorry that I can't give you a better answer than that, but
okay, just somebody wrote something on the stats. The last stats I saw were about 3% are awarded by AC and 7% are remanded. The rest are denied review.
Right. If you are, in order to win at the appeals council, you have to have them accept it for review. And 90% of them are, or more, about 90% of them are reviewed and then found to be without merit. So they don't go into an in-depth analysis. 3% are awarded, 7% are remanded. And what happens on remand is they generally ask a very narrow question that they have. For example, I had one just very recently where it was remanded because the comparison date wasn't specified in the initial decision. The judge did a hearing, came up with a comparison date and re-denied it. So, you know, just because you get remanded doesn't necessarily mean you're going to win.
That looks like all the questions or comments that we've had come in. So I would like to thank Jane for all of us for sharing this information with us today and your time. We appreciate it. Thanks to everyone that participated. I hope you got some good information out of this. And just a reminder, we have our next DAP SSI Ssdi session this Thursday at 2 p.m. So we hope to see you there. Take care, everyone. Have a good day. And thank you, Jane.
Thank you.